All right, we'll go live. Okay, so my name is Chris Berry with Castle Wealth Group. We do these weekly wisdom webinars once a week where we're just answering questions submitted ahead of time, or if you do have a legal, financial, tax plan question, feel free to put it in the Q&A, and we just go from there. I always like to start with positive focus, just something positive that's happened, either personally or professionally. My kids, my son, he's in marching band. They were just at Disney World. He's in Heartland, 10th grade, plays the clarinet, and they just got back from Disney World. He had a great time, so that was pretty awesome. And then he has swimming tomorrow, and then my daughter coaching her in a soccer game. She won her last game, scored a goal. She has Odyssey of the Mind coming up this weekend. She's going to regionals. It's kind of like a STEM or engineering with some creativity thrown in there, where basically the kids have to just kind of handle this project on their own. And then my son, the following week, he's going to States for, it's called DECA, which is kind of like a business and marketing program for high school kids. So just pretty excited that kids are kind of doing all these extracurricular activities, and it's busy though. So, all right, let's get into the questions. So the first question, let me pull it up here. All right. So the question is, what can you do with RMDs if you don't need the income? So what can you do with RMDs, required minimum distributions, if you don't need the income? So RMD, those are going to kick in once you turn either 73 or 75, depending on when you're born. Born prior to 1960, then you have to start your RMDs at 73. If you're born after 1960, you have to start your RMDs at 75. It used to be 70 and a half, and then the Secure Act changed that to 72, and then Secure Act 2.0 changed that to 73 or 75. So this is a common question of, okay, I'm forced to take money out of these accounts and I don't need the money, I don't need the income. So what can we do with that? Here's what some of my clients, similar situations will do. So the first thing I throw out there is you could do what's called a qualified charitable distribution. A qualified charitable distribution. This is a QCD. You can do it actually once you're over the age of 70 and a half. So that used to be tied to the RMD age. Now, RMDs are 73 and 75, but you can still do a QCD at 70 and a half. Now, you don't have a required minimum distribution, but you still may want to do a QCD. And what a QCD or qualified charitable distribution is you take money directly from a pre-tax IRA and you send that to charity. Okay. So I have a lot of clients that are charitably inclined. They donate to their church, they tithe, they donate to charities of their choice. And a lot of times, initially, what you're doing is you're taking money out of an investment account, whether it's an IRA that you have to pay taxes on. You pay the tax, and now you send it to the church or charity. So let's say you donate $100 a week to your church or something. I'm just making up numbers. A lot of times you just write a check from your checking account, hand that to the church. Well, with a QCD, what you can do is you can write a check from your IRA. You have to have check writing privileges. So our custodians like Charles Schwab allow for that. You have to have the cash in the accounts. But you could do a qualified charitable distribution where you're writing money directly from the IRA to the church or charity. So if you're doing $100 or $1,000 or whatever denomination, you're taking that $100 directly from the IRA, sending it directly to the church or charity. So they're getting 100% of that money. Versus if you take the money out, pay the tax, and write it from your normal checking account, you take $100 out, you got to send 20,000 to the feds, and then 80,000 or 8,000 or whatever the number is, or 800, depending on denomination, or 80%, let's say, goes to the church or charity. So once you're over 70 and a half, you can do that. And so now let's say you do have required minimum distributions because you're over 73 or 75, and you got to take out, let's say, 40,000 over the year. Well, you could take the 40,000 out, pay the tax, sending 20% to the feds, or at least some portion of that RMD you could send directly to the church or charity. and now no one has to pay tax. So it's a way to kind of cut the IRS out of your charitable giving. So that would be the first thing I would say. Sometimes people ask, can you do like a Roth conversion of your required minimum distribution? The answer is no. So you can't, oh, I have a $40,000 RMD. Can I send that directly to a Roth? You can't. You always have to take out the RMDs. It's just a matter of what you do with it. You cannot do a Roth. You can do a qualified charitable distribution. Something other clients do is they just take the money out and they gift it to kids or grandkids. That's an option. Other people, they take it out, they just invest it in a post-tax account. A little more of an advanced strategy to get some more bang for your money is, let's say you had a $50,000 required minimum distribution. Well, you could take that 50,000, pay the tax, and even if you are 73, 75, a little bit older, you could invest in permanent life insurance. So now you're getting more bang for your buck, and now the kids or grandkids are inheriting this money tax-free. So there are some options with the RMD if you don't need the income. And I would say, especially if you had charitable interests, the easiest thing is just looking at those qualified charitable distributions. So hopefully that's helpful. And if you want to talk more on that, feel free to reach out and we can go over your specific situation. All right, next question here. Dear Chris, a nursing home told our family we'd have to sign paperwork as a responsible party. Could that make us permanently liable? So the question is, someone's going into a nursing home. The nursing home wants you to sign as what's called a responsible party. I would say for me to give a definitive answer, I'd have to take a look at the paperwork. This is something that a lot of assisted livings and nursing homes did in the past, is where they try to get someone on the hook for the bills if mom or dad passed away or wasn't available. Really, I've seen most assisted livings and nursing homes get away from that specific aspect where now you're kind of jointly liable on things. So I would say, from my perspective, that would be surprising if that's the paperwork they're trying to have you sign. Just because I haven't seen that in a while, and that's pretty draconian and pretty sneaky. And there's a lot of pushback from like assisted livings and nursing homes on that in the past. So I'd be surprised if that's what's going on, but I would be concerned if they're using that language of responsible party. So I would not want to sign something that puts me liable. I'm not sure what state this question's coming in from, but most states have gotten rid of what's called, it's hard to pronounce correctly, familial responsibility. Familial responsibility. And what that's saying is you're on the hook for like your parents' debts and bills. Michigan doesn't have that. Most states don't have that. So, excuse me. I'd be careful signing anything, especially if they're telling you it's making you a responsible party. Hopefully that was helpful. Let's see what else we have. And again, if you do have a legal financial tax plan question, feel free to put it in the Q&A. Here's another one. Let me read it real quick. All right. So the question has been told a couple different ways that when someone passes, you do not need, or what are the things that you need to do when someone passes away? For example, do you need to file the paper to creditors for a month's notice when someone passes? Been told you need to contact the 3 credit bureaus and just report to them, not needing to put it in the paper. Also, if you have a current bank account listed as a trust account, person's still alive, when they pass, do you have to get a new bank account with a new tax ID number? Can you do that yourself, or does a lawyer need to use that? Please do not use my name. I won't, Jim. I'm just kidding. It's not Jim. Yeah, so really what this question is getting to is when someone passes away, what are kind of the steps that need to be done? It's going to depend on how things are set up in the individual situation. We do have like a successor trustee checklist that we give to our clients that kind of outlines what needs to happen. But whenever I have this conversation with clients, I always take one step back and talk about what happens when someone passes away. And that's where you have to go through this estate administration process. So basically kind of wrapping up their affairs, transferring assets out of their name to get it to pay the bills and then get the money where it's supposed to go. And when someone passes away, there's four ways assets can transfer. One is through joint ownership. So I was meeting with someone today, they were joint on dad's account. Dad passes away, it goes to him directly. Second would be beneficiary designation, where it's in dad's name, you're listed or the trust is listed as a beneficiary. That's where to access it, you'd have to get a death certificate. Third would be if it's owned by the trust. And then fourth, if it doesn't pass through one of the first three ways, then it ends up going into probate. And that's what we want to try to avoid because that's a 5-month court process. So really when someone passes away, unless there's assets going through probate, it's a much quicker process. So your question of, do we have to publish a notice to creditors in the newspaper? You can, but it's not required. And all that does is shut off any potential unknown creditors. It doesn't shut off like known creditors. So yeah, you could contact the legal news. I think it's like $87 to publish notice to creditors. But it's not required. And to be honest, most people, unless they actually have a probate, they're not doing that. Contact the credit bureaus. You can do that. Yeah, you can go ahead and freeze their credit. And I'm saying like credit cards, those are unsecured debt. So when that person passes away, there's no legal obligation to pay that debt, which is kind of an interesting thing. Also, if your current bank account is listed as a trust account, person's alive, we have to get a new trust account. Typically, yeah, because you're going from what's called a grantor trust, where it's in their social security name. Typically, what we have to do is we have to get a new tax ID number, new certificate of trust, saying that, hey, someone else is not the acting trustee. And because that person passed away, we need a true tax ID number for the trust versus just using the person's social security number. Is that stuff that you need a lawyer for? No, I would say you don't need a lawyer for anything really. Is that something I'd recommend that you reach out to us or an attorney? Yeah, just to make sure things are handled correctly. It's a lot better, easier to do things right the first time versus cleaning up the mess on the back end. So hopefully that was full. Let's see, I think there's one other one that I had submitted. Let me find it. Hold on. All right. It wasn't submitted, but it was a question that came in from a client that I had to answer. Give me a second here. Let me just pull it up. Oh, here we go. Client called in, wants to know what tax forms to use when showing income from his investments now that he's owned by a trust. So yeah. So in this situation, we set up an asset protection trust, which again is a grantor trust, meaning it's in the individual social security number. This is the first year that they've had it. They got a 1099 or from the investments, and the question is whether it's taxed like personal income tax, or is there a separate thing that we need to file? So this is while the person's still alive. I would say 99% of the trusts we set up are what's called grantor trust. So while you're alive and well, you don't have to do anything from a tax perspective. You don't have to file any separate tax returns. You don't have to have it taxed at a trust tax rate, which is a compressed tax rate. So typically while you're alive, if you have a trust, it's basically see-through from a tax perspective. So, which is different than what happens when you pass away, which we kind of touched upon. So, all right, that is all I had submitted. So if you do have any questions, feel free to shoot an email. We'll address them in the future. And just a heads up, I will be traveling next week for a continued education event in Texas. So it'll be warm. So we will get back to the weekly wisdom webinars March 11th. So with that, I want to